There are so many things available in this world. Few are tangible, few are intangible, few are corporeals, few are incorporeals. You name it, we have it. And what do we want to do as humans? We want to possess them, we want to own them, and we want them to be our property. Now, if I say possession or ownership, we know the concept because we have already discussed those concepts in my previous classes. Now, what is property? That is what exactly we are going to learn in my today's class. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my today's class, let us try understand the concept of property under jurisprudence. Let us start the discussion with understanding the simple meaning of property and then move to the jurist. Now, what does property means? Property is any physical or virtual entity. So it is very clear it can be physical or virtual entity which is owned by whom? Maybe by individuals or jointly by group of individuals. For what? To enjoy or to disperse or to destroy them. So this is about property. And Salmon says law of property is against the whole world, that means in rem, whereas law of obligation is only against the persons only, which is in personam. When speaking about property, he says property has three variety of sense. They are legal rights, proprietary rights, and corporeal rights. What is legal rights? Legal rights are those rights which are given by law, which includes both personal and proprietary rights, whereas proprietary rights includes the tangible and intangible things like lands, chattels, shares, debts, but they doesn't include life, liberty, reputation. Now, what does corporeal property include? They include all tangible things and they will not have any intangible things like shares, etc. Austin says property denotes rights of enjoyment, life interest, the whole of a man's assets, including both rights in personam and rights in rem. So he brings both concept, that is right against the entire world as well as right against persons. So that is Austin's definition when it comes to property. Whereas jurisprudence is limited only to property means the proprietary rights, that is in rem. And Blackstone says the sole and full dominion which a man claims over the thing of the world to exclude the others. So he says the one who is having the ownership will have the complete dominion, that means ownership, and he has the right to exclude others. That is property as per Blackstone. Next part of my presentation, I have brought the important definition given by Supreme Court of India when it comes to property, which covers both corporeal and incorporeal like trademarks, copyrights, patents, etc. And section 2C of the Benami Transaction Act 1988 says property means property of any kind, whether movable or immovable, tangible or intangible, and included any right of or interest in such property. And section 211 of the Sale of Goods Act 1930 says property means the general property in goods and not merely a special property. With that, I am moving to the theories of property. I have brought 7 important theories as far as law of property is concerned, and once you understand these 7 theories, you will have very strong idea of property. The theories are natural law theory, historical theory, labor theory, psychological theory, functional theory, philosophical theory, metaphysical theory. Let us try understand them one by one. Natural law theory has 2 important definitions and they are so easy that there is no explanation required for that. Gracious says all the things were originally without an owner and whoever occupied them became the owner. Whereas Blackstone says one who starts making use of a thing acquired an interest in that thing even for a short period or last long. That means there was no concept of possession or ownership initially, but people started acquiring things, started possessing it, started owning it, and later they became the property of such owners. That is the natural law theory. Historical theory believes that there was no concept of private property initially. There was only joint property concept was available, and then the private property concept evolved from such joint property. They say there were 3 stages. In the first stage, man had tendency to possess the goods, but then he wanted the juristic possession in the second stage, that means de facto and de jure possession. And in the third stage, he wanted right and control. For that, what does he do? He took ownership of property which is recognized by law. The labor theory, or famously known as positive theory, says property is the result of labor of an individual and who produces only can acquire it. For example, imagine there is a vacant land, somebody goes there and start doing agriculture, and just because they have created that agricultural land, they will be the owner of that particular land. That is what labor theory says. Whereas the fourth theory, psychological theory, says the property concept is all about conception of mind. whoever is having more capacity will have more property. That is supported by Bentham and Dean Pound. The fifth theory is philosophical theory, which is supported by Aristotle, Green, Hegel, etc. They have seen it in two different ways: property as a means to ethical ends and property as an end in itself. Aristotle, Green and Hegel believes that property is an end. Property is not an end but always a mean to some other end. The next theory, which is functional theory or sociological theory, is one of the most important theories of law of property, where Jens says no one can be allowed an unrestricted use of his property to the detriment to others. He said that the use of property should conform to the rules of reasons and welfare of the community as a whole, because sociological theory believes welfare of all, and if any property is restricted to a single person, according to the changes that is happening in the society, we cannot do any change because every property is restricted to individuals. That is where Lusky also says the society is changing. According to that, the rules, norms should also change, and property is not an exclusion to it. That is the thinking way from sociological theory. The last theory, which is metaphysical theory, which is most of physical connection between the owner and the object. Hegel says property is an object in which person has a right to direct his will, whereas Kant says a thing rightfully belongs to someone when he is connected with it such a manner that when someone else uses it without consent, it causes damages to the owner also. If you remember tort laws, we have studied exactly the same thing, like nuisance or trespass to the private property was considered as offense under tort law. That is what the metaphysical theory believes in. If someone wants to have the notes in single slide, this is the all 7 theory in single slide. You can take a screenshot for your examination quick reference purpose. With that, I am concluding my session on the meaning, definition and theories of property. In my next class, let us try understand the kinds and modes of acquiring property. With that, I am taking off. Thank you so much for subscribing me. Please like, share and comment my videos. All the very best for your exams, and thank you so much again.